If you agree to meet your friend for dinner but then call her an hour before to say you won't be showing up, have you anticipatorily breached your agreement? We explore the concept of anticipatory breach in Wallace Real Estate Investment versus Groves. Joanna Groves, Charles Siler, and James Siler agreed to sell a parcel of land to Roddy Cox for approximately $1.5 million. Cox later assigned his interest to Wallace Real Estate Investment. We'll collectively refer to Cox and Wallace as Wallace. Wallace gave the sellers a $20,000 note as down payment. The parties' contract provided that the sellers could retain the deposit as liquidated damages if Wallace defaulted. Although their initial agreement called for closing within 60 to 90 days, the parties ultimately negotiated multiple extensions of the closing date. For each extension, Wallace agreed to pay a set sum. The final extension agreement provided that the sale would close on December 17, 1990. If Wallace defaulted, the sellers were entitled to retain the deposit and all extension payments as liquidated damages. On December 13th, Wallace advised the sellers in writing that it couldn't close on the 17th and asked that the closing date again be extended. The sellers refused and advised that they were prepared to close on the 17th. Groves and Charles Siler appeared at the closing. Wallace didn't attend. James Siler likewise didn't attend due to health problems. However, Groves and Charles mailed the necessary documents to James, who signed and returned them via mail. The signed documents were delivered to the escrow agent on December 21st. The sellers subsequently canceled the sales contract and retained the down payment and extension payments, which totaled $260,000 as liquidated damages. Wallace sued the sellers to recover the retained amounts. The trial court found that Wallace's December 13th letter constituted an anticipatory breach of the sales agreement and that the sellers were entitled to retain the down payment and extension payments as liquidated damages. The Washington Court of Appeals affirmed. The Washington Supreme Court granted review.